Your case is scheduled to begin trial in just 2 weeks, and now the defense calls me up and says, listen, we'd like to mediate your case. Well, what happens next? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. Today I'm coming to you from sunny Sanibel Island, Florida. My wife is on the beach picking shells, and I have a few minutes to share with you some great information before I have to go meet her and catch up with her for lunch. Now, when the defense turns to us and says, listen, Mr. Oginski, we'd like to try and mediate your case, what does that mean? It means they'd like to try and engage in settlement negotiations, but they don't want to do it privately, one-on-one, and they don't want to wait until trial before getting in front of the trial judge to try and negotiate. So now they want to try and get us into a private negotiation session, which is really what mediation is. It's an ability for us to go before an impartial judge who now will listen to each side. A mediation really is an opportunity for us to have settlement negotiations privately. Both sides will hire a private impartial mediator that we both agree on. Once both sides have agreed on who's going to be the impartial mediator, now we show up and we go ahead and plan on spending a half a day or a full day there, where we get an opportunity to speak to the mediator and explain to him or her why we believe our case is worth a certain amount of money. And the defense turns around and says, listen, we recognize the injured victim is entitled to something, but we don't think they're entitled to as much as they believe they are. And literally, we have an opportunity to go ahead and explain and flesh out all the details in the case and have the impartial mediator try and mediate and negotiate this particular case with the hope and with the expectation that we can arrive at a mutual agreed conclusion and try and settle this case during this process. A mediation is an opportunity to get the defense to come to the table with authority to settle this case. The question always is, well, how much are they willing to try and settle for? What's their maximum number? And what are we willing to accept? And if those numbers are not in alignment, then we have the ability to get up and walk away and still proceed forward to trial. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in the litigation process as the case is coming closer to trial and the defense turns around and says, listen, Mr. Oginski, we'd like to try and mediate this case. Are you willing to do that? You know, I realize you're watching this because you have questions of your own. Well, if your matter happened in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I'd be happy to talk with you. I do this every single day. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.